Week 4 of my analysis of Mark Herrmann's The Curmudgeon's Guide to Practicing Law. How to write a brief. We're getting into the really exciting stuff now. Introduction. Should be 1 or 2 paragraphs, no footnotes, don't want people reading too much from the introduction. Say something exciting about the case. Keep it brief. Next, allegations of complaint in a motion to dismiss, or undisputed facts in a summary judgment motion, or the facts for most other briefs. Bring the reader up to speed on every fact you're going to mention in your argument. Don't mention irrelevant facts, and use short sentences. Then there's the argument. Say why your client should win. Break it down into different paragraphs devoted to the reasons why your client should win. The conclusion explains basically the court should grant your motion or deny the other party's motion. Very straightforward. As far as stylistic tips go, you want to avoid alphabet soup. That is, if there are agency names, you can perhaps use them if they're names like FBI or CIA, but don't use acronyms for things that are not well known. Use words as short-form descriptions for things. For instance, if your client's company is National Splendid Dyeing Company, NSDC, call it National Splendid if you want to make it sound large, or Splendid Dyeing if you want to make it sound like a smaller company. Use the words instead of the letters, because they're more memorable and they enable you to manipulate the way other people will see your client. Generally, you should also use the parties' names rather than their status in the litigation as well. For instance, you want to say we represent Walmart, not the defendant, because the defendant sounds so impersonal, whereas most people will have positive memories of at least some point in the past using Walmart. And at the very least, it humanizes your client to use a name rather than a label. This applies less depending on how infamous your client may be. We represent the defendant, in some cases, rather than, say, Ted Bundy or Saddam Hussein, because their reputations are worse than the reputations of defendants on average. Try not to use block quotes in your text. They are annoying for judges to read. If you must do that, assume that the judge will not read them, and instead, trick the judge into learning the material anyway by summarizing the substance of the quote in the previous sentence. Use argumentative headings. Say, this court should do such and such thing because the Commerce Clause does not extend to such and such thing. You want to make the person see things from your perspective, so your heading shouldn't be neutral. They should control the frame of the argument to the extent possible. And finally, to the extent you are able to do this, keep it short. Short and sweet is how people like both briefs and YouTube videos, so that's all for today. If you like this, I hope you'll tune in next week for the next exciting chapter on the Curmudgeon's Guide to Practicing Law. Until next time, have a good one.